So let's discuss the cyberstalking statute in Louisiana. So what is cyberstalking? Well, in Louisiana, it's a few different things. One, it could be using email or electronic communication to threaten to inflict bodily harm on another person for the purpose of extorting money or other things from that person. It could also be using email or electronic communication repeatedly for the purpose of threatening, terrifying, or just harassing another person. It could also be using email or electronic communication, such as social media, to make a false statement about somebody for pretty much to threaten, terrify, or harass. So, I mean, this could be just posting something on Facebook or social media, a false statement just to harass somebody. It's also knowingly permit an electronic communication device under the person's control to be used for taking any action that we just described here. So this is pretty much just allowing it to happen. So the penalties for cyberstalking in Louisiana, they vary. It is actually a misdemeanor charge, believe it or not, even though it carries a very lengthy prison sentence. Reason is because the statute doesn't prescribe with or without hard labor. And that's what determines whether or not a charge is actually a felony in Louisiana. The reason this is important is because this actual charge allows for a jury trial of 6-person jury, as opposed to just a judge trial, which a misdemeanor up to 6 months would be judge trial only. So as you can see here, first offense, cyberstalking, looking at a fine of up to $2,000 and imprisonment or imprisonment for not more than 1 year. So a judge could give a defendant 1 year in prison for this charge on the first offense. Second conviction within 7 years, then they're looking at not less than 180 days and not more than 3 years. So it gets extremely serious. And then if there's third or subsequent conviction within 7 years, it's 2 years to 5 years. Also, regarding the penalties, the judge can order that that the computer, the phone, anything having to do with the communication be seized and sold. So it even lists down here in section B, motor vehicle. So if a motor vehicle, they can prove that a motor vehicle was used to make the communication, they could seize it and sell it. So this is pretty serious. And the jurisdiction where the charge can actually be brought is always important. The statute pretty much makes it to where it can be brought anywhere. So it's going to be where the email was sent from. It could be where it was received. So say for instance, somebody in California sends an email to somebody in Baton Rouge, Louisiana. Well, that person in Baton Rouge, Louisiana, they're sitting in their house or their apartment and they open the email or they see the Facebook posting. Well, the charge can be brought in Baton Rouge, Louisiana. Just like how it says down here, originally viewed by any person, so wherever they see it, and that could be any person. So it gives a lot of leeway to the prosecutors here. If you've been charged with cyberstalking, feel free to give me a call. I'm Barkemeyer, criminal defense attorney. I handle these all throughout Louisiana.